Good morning.
Morning.
Morning. Your Honor, I'm Barry Kuhn. I'm with the Shelby County Public Defender's Office.
And let the court thanks you and Mr. Coleman for moving this case up. Save us from just having a lot of dead time this morning. We appreciate it. We had a case that was continued at the last minute.
Well, I would like to thank the court for moving it up because I'm going to have the rest of the day off when I get through here.
It's a win-win.
I appreciate it. Your Honor, the defendant in this case, Keedrin Coppage, was convicted of murder first degree, and he got a sentence of life in prison. He was also convicted of tampering with evidence, and we're not contesting that. We're not really contesting that he is the person who committed the homicide. What we're contesting is that it shouldn't have been murder first degree. The main issue in the case is whether or not there was sufficient evidence to show premeditation. According to the defendant's account of the things, and that's the only account we have of what actually happened, because he was the only one present during the homicide, that he and Mrs. Wynn, Sabrina Wynn, was the victim, and they had a long-standing, a year and a half to 2 year romantic relationship with one another. And it was January the 2nd. They had spent January the 1st together, New Year's Day together. On January the 2nd, they were in the car traveling somewhere. Mr. Coppage says they got into an argument and a fight. It got violent. She produced a knife. He got the knife away from her. He stabbed her multiple times. She bled to death, and he deposited her body out on the side of the street in Memphis. That's what he says. And the issue with premeditation is that it has to be an act free of excitement or passion. And I submit there's no evidence in the case that shows this the homicide was free of excitement or passion. Just the contrary. It appears from his testimony that it was. The problem in the case, and the main issue I want to argue, is that so much evidence came in about his character and about prior acts of assaults and violence against the defendant, against the victim, came in through hearsay evidence. The evidence of, and one, the evidence of the character evidence, we say violates 404B of the rules of evidence. And that most of that evidence, there's 11 incidents of violence against the victim, against Mrs. Wynn, that was testified to by witnesses in the case. 10 of them were proven by hearsay evidence. They were things that Mrs. Wynn had told them about these prior assaults. She had called the police a number of times when she says that he had assaulted her or kidnapped her or raped her. So the 404B evidence comes in. One, 404B evidence to be admitted has to be clear and convincing. It has to be proven by clear and convincing evidence. And I would argue that evidence can never be clear and convincing when it comes in through hearsay, because hearsay by its nature is unreliable.
Well, let me ask this question. I'm a little bit confused from reading the briefs. I think the
Yes,
state
ma'am.
says we don't have the transcript from that, but your reply brief, I think, indicated we do.
We do.
It is in the record? Okay.
Yes, ma'am.
Okay.
Yes, ma'am.
I know
looked
the
at-
trial court's order had extensive findings, but I thought we actually had the transcript as well.
We do, and what happened there was, when I got the record from the Court of Appeals clerk here, I looked at it and I saw that those transcripts on those pretrial motions was missing, so I had to go find them, and I found them. The court reporter still had them, so I filed a motion to supplement the record, which was granted, and then I filed those, and it's now part of the record. And I listed the volume and page numbers in my reply brief to show where those are. So I don't think there's any problem there. I don't think the state's going to still contest that we don't have those. So Anyway, those are there. So the main issue, the two main issues I want to argue about, and most of the rest of it I'm going to submit on just on the briefs. The other, I think we allege 11 or 10 or 11 errors in the judge made, but I'll submit those. But the main things are the proof of all of these prior assaults by the defendant against the Mrs. Wynn. She wasn't available because of hearsay. She's not available for cross-examination. And there was a couple of examples that one, she told her brother that when she was kidnapped and taken to Nashville on that trip that she said lasted 3 days, she said she was kidnapped and when it happened, and yet she told Officer James Harden about it when he investigated it. She told him, or at least he got the impression from what she said, that it was voluntary. So there's some conflict there that we didn't get to question her about. She said she had been kidnapped at one point when she had a petition for protection pending in the General Sessions Court in Memphis. I'm sorry, I didn't say 2. I'd like to reserve 5 minutes for rebuttal if I can. She said, in sort of protection, she said she was kidnapped at knife point by the defendant in the morning at between 8:30 and 9 o'clock in the morning in front of 201 Poplar, which is a criminal justice center, on a weekday, which is a very, very, very busy place. And of course, the cross-examination would like to consist of how could that happen? How many people were there? Where were you? And so forth. But, you know, I think this indicates that a lot of our hearsay testimony was unreliable. Not just that hearsay itself is unreliable, but things she said were contradictory. So they allowed the hearsay evidence to come in under the forfeiture by wrongdoing exception, which says that you can show that the person who objects to the hearsay evidence prevented the declarant from coming to court, that he can't then object to the evidence. But there isn't any evidence that there was, in fact, the evidence is that there weren't any cases pending at the time that this homicide occurred. There might be some indication that he thought that maybe she was going to bring action against him. I think he even said on the statement to the police that when the homicide occurred, when the fight occurred between him and the homicide occurred, that she said something about, I'm going to bring some more charges against you. But I would argue that there's got to be more proof about that to show motive than just the speculation that, well, he knew that there might be more charges brought, so therefore he killed her to prevent her from coming to court. There's not any proof that that was his motive. And in fact, I doubt, you know, if that was his motive, he would have told the police about it at the time.
Is there proof about whether or not any of these assaults that were testified, that you say were hearsay, occurred fairly closely in time to the homicide?
Your Honor, I think the first one occurred sometime in June or July, and then there were some in September, and then there were more, I think, right up in December, leading up to when the homicide occurred. And I'd have to compliment Mr. Cherry on the brief he wrote, because he organizes in his statement of facts the events. And my statement of facts follows the testimony in court, but he did a good job of organizing things so you can see when these events occurred, and I think there were 11 of them. There's only one when there was an accident that the defendant attacked Mrs. Wynn and dragged her by the hair across the street, and it was a terrible, terrible thing. The whole thing is a terrible series of events, and it's awful what happened. But they just hadn't any proof it was premeditated. He didn't pick her up that morning on January 2nd in order to murder her. They had their usual relationship. They got in the car, and they got mad at each other, and they started arguing, and a fight broke out, and a knife was produced, and she wound up getting killed.
But don't a lot of those facts about their kind of tortured relationship can't they be considered for premeditation by the jury? I'm pretty sure that's in the instruction. You know, the history between the two, and obviously extensive number of stab wounds.
I guess it could be considered as, well, it seems like more reasonable that because they had all these history of things happening where there wasn't a homicide, that it was just another series of this kind of fights that they had with one another. But yeah, I can't argue that the jury couldn't consider it, but I think because it was so bad, and Judge Lammy talks about this in his sentencing hearing about what a terrible person the defendant was, that he tortured Mrs. Wynn for so many months before this homicide occurred. And I think that's what the jury must have been thinking to hear all of this evidence. I just think it clouded their judgment, and that they...
You're not suggesting he said that to the jury?
No, ma'am. Okay. No, he said that was at the sentencing hearing. I'm sorry.
Right, that's what I thought.
Yeah, that was just at the sentencing hearing. He sort of gave his feelings about how he felt about the defendant at the sentencing hearing. And, but I think that probably would have been the effect upon the jury, and that's why this evidence shouldn't have come in. And one thing Judge Lammy did, and I'm about to run out of time here, but let me just mention this, that he let this evidence in showing their prior relationship in, but when the defendant wanted to introduce some evidence through some audio exhibits, to show that they had a romantic relationship, a good relationship with one another, he didn't allow that. He said that wasn't relevant.
Well, I mean, were those really like kind of just sex tapes that he was wanting to admit?
Yes, ma'am, I think so. And I've listened to them.
You're arguing that those are relevant?
Well, I think that if you want to get their relationship in, and that's why he let in this character evidence that came in to show it showed their relationship, that you need to give the jury the full picture. They're hard to listen to. I mean, when I've listened to those tapes and can't really tell what they're saying, but you have to kind of get the evidence is what it sounds like more than actually what the verbiage is. That's basically it. I've got 3.5 minutes left. I'll save that for rebuttal.
Right,
thank you. Yeah, I don't know if there are any further questions.
I'm good. All right,
Thank you, Ron. Appreciate it.
Mr. Goldman?
Good morning again, Your Honors. Ronald Cohen on behalf of the state, filling in for Brent Cherry, who has just recently retired. So congratulations to him. This court should affirm the defendant's judgments because the evidence was overwhelmingly sufficient to establish his guilt and because the trial court properly exercised its discretion in making evidentiary rulings. As an initial matter, Judge Ayers, the state does have a bit of a mea culpa. This was a voluminous record, and we apparently simply missed these transcripts of the pre-trial motions. They are in the record, so the waiver claim is incorrect. But even on a plenary review, the trial court properly exercised its discretion. And since these evidentiary rulings sort of tie into the sufficiency, I'll address them first, unless this court has other questions. First, the defendant claims that the trial court abused its discretion in admitting sort of prior acts of the defendant's increasingly hostile attitude and increasingly violent attacks on the victim here. But instead, the trial court properly exercised its discretion. These were properly admitted to establish hostility towards the victim, malice, intent, and a settled purpose to harm the victim. I think it's important to note what these prior acts all were, and they are not general acts of the defendant towards random people to allegedly establish propensity for violence. Instead, these are acts that the defendant perpetrated on the victim repeatedly and showed an escalating nature. And that the Gilley opinion in our Supreme Court has said in Gilley that is appropriate. That is not use of propensity evidence. Instead, that is for a different purpose, which again goes to show the defendant's hostility and settled purpose to harm this particular victim. And for that reason, those acts were properly admitted to come in under Rule 404B. And the defendant also complains that they should have been excluded, or some of them should have been excluded, because the way they were introduced was through what he feels is inadmissible hearsay. But again, the state submits that this was a proper exercise of discretion because it was the defendant who caused the victim's absence. The defendant complained several times that cross-examination could have impeached the victim, and that, quote, "we didn't get to question her about that." And the fact of the matter is that's because the defendant killed her. The defendant argues that there were no cases ongoing at that particular time. But I think to your question, Judge Holloway, as to whether there were recent events. So these events started months before the murder, but as little as 5 days before the murder, there was an incident. There was an incident on December 27th, and that's on volume 11, page 840 of the record. A few days before that, there was an incident on December 20th to 23rd, which I believe is when he kidnapped her and took her to Nashville. That's on volume 11, starting at page 799 of the record. And there was an incident before that on December 16th, on volume 11, page 740 of the record. So these were not only increasing in nature, but were very close to the time of the murder. And while prior orders of protection had either run or were dropped, these were cases where an order of protection could have gotten out.
But there were no orders pending at the time.
There were no orders pending at the time, but I think it's critical to focus on the defendant's own admission. When he talked to police, he said that before he killed this victim, Miss Wynn, he heard her say that she was going to press some more charges. And so it was reasonable for the trial court to say, part of this doesn't have to be the entire motive for the murder, but a part of, a contributing factor for why he killed her was so that she would not press further charges. And that's a reasonable exercise of discretion in doing that. And then briefly, the other evidentiary claim that I've heard the defendant raise today is that he wasn't allowed to introduce some audio of prior instances of establishing their romantic relationship. And I think, Judge Ayers, your question sort of cut to the quick, is that was not relevant. Nobody was challenging the fact that they were in a romantic relationship. Nobody was challenging the fact that there were some good times in that relationship. It's just that there were bad times too, and one of those bad times, the defendant killed this victim. And so it had absolutely no relevance whatsoever that at some point, well before this murder, the defendant and Miss Wynn were in a good spot. That just it has no relevance to the murder itself. And unless there are any further questions on the evidentiary rulings, I'll turn to the sufficiency. And here the evidence overwhelmingly established guilt. The defendant readily admitted that he was the one who killed Miss Wynn. And so really the question for the jury was about whether there was premeditation. And looking at the factors to establish premeditation, there are an abundance of those for the jury to rely on. First, the escalating series of attacks showed that at some point this was going to was going to cause a murder, and that the defendant was premeditating this. Perhaps more importantly is the number of stab wounds. I don't want to get into too many details, but the victim suffered 38 stab wounds. The defendant stabbed her 38 times. The repeated number of attacks is a factor that the jury can rely on to establish premeditation. The fact that the defendant did not seek medical aid is a factor that the jury could rely on to establish that this was premeditated. And there are an abundance of factors. The evidence overwhelmingly establishes guilt here. It seems like the defendant's other issues have been left on their brief, so unless this court has questions, we will also rely on our brief with those and simply ask this court to affirm the judgments here. Thank you.
All right, thank you, Mr. Coleman. All right, Mr. Coon.
Thank you. In response, I would say with regard to that sufficiency argument, it may or may not be sufficient. I don't want to concede it was, but I want the jury to hear the case that the court would present without all of that hearsay testimony, without all the character proof that came in, then let them decide if it's sufficient or not with that. And that's why what I'm asking for in this case is that judgment be set aside and the case remanded for a new trial without the evidence that we've objected to. I think the argument with regard to the 404B evidence coming in not as prior act, but as to show the relationship was there was a hostile relationship, and that's what I remember Judge Lammy in his order saying it showed hostility and malice. That's not really an issue, I don't think, because there was certainly hostility and malice when on the date that the homicide occurred, when they were in the car and got in a fight, and he killed her. So I don't think that it was. I think it doesn't meet the balancing test. It's so much more prejudicial than it would be probative. And again, I think it's just speculation as to if he did these acts because Mrs. Wynn said while they were in the car and after they were fighting that she might bring more charges. The hostility had already occurred, the assault had already occurred, they were already engaged in this passionate exchange, the physical exchange between them. So I don't think that would indicate anything. Finally, there's a couple of places I would like to tell the court I made some mistakes in my brief, and just briefly, if I could get this. On page 44 of my brief, in the third paragraph, I say that the state waited until 2 weeks before the trial date to produce the evidence. It should be 1 month, not 2 weeks. There was 1 month before that was the DNA evidence that they wanted to introduce, and the defense asked for a continuance so they could check it out. And on page 52, and this is the objection about these transcripts of recordings. The transcripts were done by a secretary in the state attorney's office. I say, and this is in the fourth paragraph, I say the recordings were made by a secretary of the state's attorney. I should say the transcripts of the recordings were made by a secretary of the state's attorney. And that's all I have. Thank you so much for listening to me. Appreciate it.
Thank you, Mr. King. Okay. We're going to take about 5 minutes. We'll come back and do the last case.
All right.